Yep, there I am. Should I turn my microphone on here?
All right, everyone. Stacy Cross, did you have a chance to speak with your client?
I did. Is she in here yet? She's gonna log in with on the Zoom.
No, she's not logged in yet.
Okay.
Is there Valeria Garay? No, she's not on the Zoom screen yet.
Okay. But yes, I did have a chance to speak with her. She does want to make a statement to you, Judge. And I guess I'll be present for that statement.
Yes.
But otherwise, I think everything is going to be fine.
Okay, thank you. And for everyone else, I'm just on Hemp Hill, I'm just receiving the plea paperwork. So I'm signing that now.
Your Honor, John Young and my client Anthony Salinas are in the courtroom.
All right, just give me one moment, Mr. Young. All right, Mr. Is there anyone who needs to go to a breakout room, first of all, with their client?
Your Honor, Robert Gebbia here. I'd like to go into a breakout room with the prosecutor for Christopher Lemire.
Is it criminal trial division or family violence?
Excellent question.
Let me check. I'm unsure because it doesn't state. Christopher Lemire, it's a burglary of a habitation with intent to commit assault. I'm going to send Robert Gebbia to a breakout room if one of the prosecutors could join him there, whoever case that would be. Bobby, I'm going to send you to breakout room number 2.
Okay, it's an MTR also.
Yes.
And Judge Joe Ray Garcia and I just need to approach for a moment.
Yes. Yes, on that case, Joe Ray, my understanding there's some issues with discovery or whether discovery is, some officer may have it or not have it.
Judge, as far as we know, we don't have it. And I think PD was subpoenaed and they stated they didn't have it either. It's not on this case. It's about unrelated case on the complainant.
Well, that's true, but we were SAPD was gonna check with the detective who wrote up the charge and disposition report on that criminal mischief case to see if he personally had retained it. And that's who I was wanting to know if the state can inquire with him.
Okay, and is that related to this case or related to how this case will resolve itself?
Most definitely. in my
All right, so
opinion.
let's do this. So State, are you able to get in touch with the detective or whoever it is? To have them, do you want him present, Ms. Efron?
Just to know whether or not he has it, if he has it in his possession or not.
Okay, so do you want him present in court or you want the state to get in touch with this detective? What do you want done? You want him present on Zoom?
Um,
Does
It's
anybody
really-
know when the detectives speak with the defense attorney?
I have to look at it, Judge. I don't even know who it would be.
All right, so we're gonna find something out, Ms. Efron, before we leave.
I know who it is, and I have his badge number.
All right, so let me do this. Let me send, well, before I send Joe Ray into a breakout room, the case that we're on right now is Joe Ray's case with Miss Garay, and Miss Garay is here and the defendant's in the courtroom. So let us take this matter up and then we'll figure out what's happening with that, Miss Efron.
Your Honor,
Yes,
my client is ready to be sworn in. If you could send us to breakout room number 1.
yes,
Thank you, Your Honor.
you're welcome. Brenda, it looks like the sun is trying to make an appearance. Just enough to make it hot and humid and muggy, but hey, it's still the sun, right?
Make you feel like you're in Louisiana.
All right, we're back on the record in 2021 CR 4792, State of Texas versus Eric Garay. And where we left off is the defense wanted to call a witness, Valeria Garay, who was in the courtroom with the defendant, even though there's a no contact order that's in place. An attorney has been appointed to represent Miss Garay, and that would be attorney Stacy Cross. Is that correct, Ms. Cross?
Yes, Judge.
All right, and have you had a chance to confer with your client, Miss Valeria Garay?
I have, Judge, and she would like to, testify and make a statement still.
All right, so defense, it was your witness. She had already been sworn in and stated her name on the record and spelled it. So defense, you may proceed.
Thank you, Your Honor. Ms. Garay, you were here to testify for your husband and the application as to his application for probation. Now, what is it that you want to address the court about that?
For my husband to be able to get probation. I don't want him to go to a prison. He has a job. His kids want him at home. I want him at home too as well. And but we just miss him. I mean, mistakes that he made, and we don't want him to go away. Like we really need him at home.
How many children do you have?
We have 4.
Okay, and the 4 children are with you right now?
Yes, sir.
They live with you, in other words.
Yes, sir.
Okay, and so you're asking the court to grant your husband's application for probation at this time?
Yes, sir. Mhm.
And are you, what are your plans if he does get probation? And of course, we're gonna have to deal with the protective order where
Yeah.
there is no contact protective
Yeah,
order.
I would like for that to be removed, and for him to be able to come home to us and his kids.
And your plans are to try and straighten out your lives, so
Of
you
course,
can go
yes.
on.
Yes, definitely, sir. I would love to make different changes for our lives since we've been married already for 18 years, for a long time. And I don't plan to leave him. My kids, they miss his dad. I miss him as well too. I mean, I know we all make mistakes. He made mistakes and everybody's willing to change.
Okay, do you think that if the court grants his probation, he could better himself with some type of treatment for the problems that he has, being
Yes,
drugs or alcohol, whatever it is, problems and anger issues?
yes, sir.
And do you have anything else to tell the court?
No, just me, myself, I'll be to support him, to guide him and just guide him to a good path so he can stay with his family.
Okay, that's what I have, Judge.
All right, state any questions?
Yes, there's just a few factual clarifications. Ms. Gray, you gave a victim impact statement to probation in this case, right?
Yes, sir.
Okay, and in that statement, you told him that you're concerned with him getting probation, right?
Concern, yeah, I want him to get probation. I want him to help
That's
himself.
that's not what I'm asking. I'm asking
Oh, I don't
what
know.
you told them that you're concerned with him getting probation.
But I'm concerned of him getting probation.
Yes, because you're concerned he's going to mess up, right?
Yeah, but that's why I said I want to help him. I want to guide him. I want to be for him to go through it, all of it, so that way he will not get in trouble.
Okay, and this isn't the first instance with involving him and you where family violence was involved, is it?
I'm sorry?
This isn't the first offense of family violence where the police were called involving himself and yourself, is it?
This is not the first one, no, sir.
There's been several others before
Yes,
this?
sir.
Okay, no further questions, Your Honor.
All right, any other questions?
Just a couple, Judge. Ms. Garay,
Yes, sir.
do you think that your husband has changed from the times that the other incidents took place to the present time?
Yes, they have.
So you think there was some treatment, it would get him straightened out?
I believe so, sir.
Okay, that's all I have, Judge.
All right, any other questions?
No, Your Honor.
All right. Ms. Garay, if you'll just remain on the Zoom, there may be more questions that may be asked of you.
Yes, ma'am.
And Ms. Cross, if you could remain, please. All right, defense.
Your Honor, before I call my client to the stand, I'd like to point out that he is applying for probation, and according to the TAP evaluation, they're recommending intense outpatient treatment. And I had spoken to my client about that, and he says that he could abide by anything that the court would, any conditions the court would place on him. So I'd like to call him to the stand for him to address the court directly.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record, please.
Ray Eric.
All right, defense.
Okay, Mr. Garay, you're here asking for the judge to grant your application for probation in this case. You told me you wanted to address the court, so what is it that you want to let the judge know?
I apologize for having y'all babysit me. I'm sorry for the mistakes I made. I'm willing to apply. I'm willing to obey all the orders that you give me for probation. I don't want to go back to prison. That's just.
All right, not to interrupt you, but one, nobody wants to go to prison. People who are at the Bexar County Jail don't want to be there now.
Yes,
Number
ma'am.
two, what you've made have not been mistakes. What you've made have been choices.
Yes,
Do you
ma'am.
know what the difference is between a choice and a mistake is?
No, ma'am.
Let me give you an example of a mistake. As you all know, it was raining today, right?
Yes,
I
ma'am.
leave my house. I bring my umbrella with me. My umbrella is a black umbrella. I come to court. I sit down next to somebody. They have a black umbrella. As I'm leaving the court, because I know it's raining, I take my black umbrella. I go outside. I open it up and I look inside. Lo and behold, the umbrella is black, but it is not my black umbrella. That's a mistake. Let me tell you what a choice is. I come to the courthouse. It's not raining outside. The weatherman didn't say it was going to rain. I'm getting ready to leave the courthouse. Somebody says, hey, you know, it's raining outside. I see that somebody in the courtroom has brought an umbrella. They're not around. I take their umbrella and I go outside and I use it because it's raining. You know what? That's not a mistake. I knew I didn't bring an umbrella to court. I made a choice to take somebody's umbrella. So the violence that you've shown against Miss Garay, those are not mistakes. Those are choices you made. This whole thing about you in the car with her, driving to do laundry, she's changing the radio, you hit her hand. That was a choice you made. That wasn't a mistake. You intended to hit her hand. The whole thing where people are saying in the police report that you pushed her against the car and then pushed her on the ground, that's not a mistake. That's a choice you made. The whole grabbing of the phone from her, that's not a mistake. That's a choice you made. Ruining everyone's day who was at the laundromat just there to get their laundry and minding their own business. Now they got to talk to the police and say what they saw. That's a choice you made, not a mistake. The fact that you know you have a no contact order with Miss Valerie Garay and you come to court all loved up in the courtroom with her, that's a choice you made. You knew that you had a no contact order and you violated it. Those are choices that you made. So here's my question for you, because you've been making a lot of bad choices. You can't even abide by a no contact order. Why should I think that you can abide by terms and conditions of probation? That's my question.
Because I love her, man. I love her so much. That's my wife, man. It's hard for me to stay away from her.
No, don't even say this whole thing that you love her so much, because if you love her so much, then why are you hitting on her?
I don't hit her, man.
Oh, no. I just heard testimony that this is not the first time there's been violence between you two.
I've never hit her.
Don't be, here's the thing.
Yes, ma'am.
Don't be dishonest with the court. I've read the report. I've seen your criminal history. Let's not be dishonest.
Yes, ma'am.
I've been a defense attorney. I've been a prosecutor. Once you enter a plea, you want to throw yourself on the mercy of the court, ask for forgiveness from your wife that you say you love, that you keep hitting on. Fine, do that. But don't come to court and don't be dishonest with me, because then we're going to have a major problem. Do you understand?
Yes, ma'am.
So whatever you've done that has been disrespectful to your wife, and by that way, disrespectful to your children and ruining their day, you need to own it. Do you understand?
Yes, ma'am.
You may continue with your questions.
So, Mr. Guy, why are you asking for probation? Tell the judge why you're asking for probation. What are your intentions?
If you give me a chance, ma'am, I can change my life, ma'am. I can show you that I can change. That's all I'm asking, ma'am. Please, if you can give me probation, I can show you and the court system that I can change, ma'am. I'm just a human being, ma'am, just like everybody else. I know I made my choices, but I just want to be around my kids and my wife, ma'am. And if you could give me a chance to show you that, it's 5 years, ma'am. It's a long time. And I believe I can make those 5 years. I can accomplish something within those 5 years, ma'am. If you could just trust in me, and I won't let you down, ma'am.
Oh, it's not me you're letting down. You mean you don't want to let your wife down, but I can tell you right now, if I grant your application for probation, there's going to be a no contact order. So you're not going to be having contact with her. So you can get that out of your head right now. This whole thing where I just want to be with my wife and love my wife, there is going to be a no contact order. So let's start from there.
If I do good for the first 2 years, is there a way I can be able to see my wife again, or I have to finish the whole 5 years on probation before I can see
Now
my
you're
wife?
negotiating with me. So you go from please give me probation to now you're trying to do a negotiation with me. This isn't a hostage situation. This isn't the negotiator.
I don't know how to speak, ma'am. I'm just telling you how I feel.
You just listen to the questions that your attorney is asking of you and answer those questions.
I have no more questions, Judge, at this point.
Say.
Just a few, Your Honor. Mr. Gray, you have a total of 9 convictions. Isn't that right?
I don't know, sir, if I do or not, sir. Can't tell you yes or no.
You don't know how many criminal convictions you have?
I know I have 2 DWIs. That much I know.
Okay, you know that you've been on community supervision 3 times, right?
I can't say yes that I have, sir. I know I've been in prison, sir.
Okay, you've been to prison and you don't know how many total cases you've had,
I've been on parole. And I've
and you've been on
completed that.
parole.
Yes, sir.
Okay. And in the PSI, you're stating that you never pinned her against a car or threw on the ground. Is that
No,
right?
sir. Yes, sir.
So your statements today are that the police report is wrong?
No, sir, I'm not gonna say that, sir. You could even ask my wife, sir. I didn't do that, sir.
Okay, so my question is, the police report is wrong. If it states that.
No, sir, it's not wrong, sir.
It's not, so you did throw her on the ground and pin her against the car?
No, sir, I didn't do that, sir.
Okay, so you're stating that the police report is wrong.
Yes, sir.
That's what it states.
Yes, sir.
Okay, and you're stating what your wife told the officers was wrong that day as well. Is that right?
The officers wouldn't let me talk to my wife, or they didn't let me speak at all, sir.
Mr. Gray, just answer the question with a yes or no. If it states that your wife told the officers that day that you pinned her against the car and that you threw her on the ground and you pinned her on the ground, taking her phone away, you're stating that's wrong, correct?
Yes, sir.
And you're stating that the 2 witnesses that were there that didn't know y'all are wrong as well. Isn't that right?
Yes, sir.
Okay, no further questions, Your Honor.
Anything else from the defense?
Mr. Gurray, that day, you did have a confrontation with your wife. Yes or no?
Yes, sir.
I can't hear you.
Yes, sir.
Okay. And what was the purpose of that encounter? What is it that you wanted to do?
All I said was, you lower the radio down, and all I did was just lower the radio down, and I didn't hit her hand or anything. My hand got in the way. She reached for it too, and our hands kind of just went like that.
Okay, I'm not asking you what you did. What is it that you wanted to do when you got out of the car?
Just go and wash clothes, just the way we had gotten there in the very first place.
Okay, did you at any time attempt to take her phone away?
No, sir. Well, when she had called, I had told her, please don't call the cops, because I wasn't doing anything to her. And I tried to reach for the phone, and that was it, sir. And after that, I just moved away from her, and that was the whole thing. And there was cameras there watching everything, and the cop went inside. He saw the cameras. He came outside. He said, "Look, I saw that you didn't do anything to her, so you're pretty good right now. So just wait." And then he said that I had priors. That was the only reason why he took me to jail, because I had priors. That was
Okay,
that's what he
okay.
told me.
So the whole thing.
There was nothing because I hadn't hit my wife or nothing like that, sir. The only reason he took me in was because I had priors to he had looked in the computer, he said I had priors. That was the only reason why he was taking me in, sir. And he didn't explain nothing else to me.
Judge, I have no further questions.
All righty. Anything else from the state?
No, Your Honor.
All right, any other witnesses defense?
No, Your Honor.
All right, Mr. Gray, if you drug tested today, what are the results going to be?
Clean, ma'am.
Before you answer, know that I can have you drug tested today. So knowing that you can be drug tested today, and there's a person right across the hall that will do it, what are the results going to be before it's done? Tell me.
Well, the people who I'll probably come out dirty, man, for marijuana.
And what else?
That's it, man, because I hang around with people that smoke.
Oh, don't do that. I hang around with people who smoke thing. Don't do that. So what are you going to be positive for? And you need to pull that mask over your nose. What are you going to be positive for?
Marijuana, man.
And what else?
That's it, man.
All right. Jorge, you want to talk to your client about his UA and what the results are going to be? Or do you want to continue?
Yes, let me talk to him, Judge.
All right, courtroom, could you go to breakout room number 1, please? All right, and on Hemp Hill Hunter, I signed everything that I have. For some reason, that discovery acknowledgement,
It came
It-
through, late, Judge. I signed it. I found it. It should be there, and I think Libby should have gotten it.
okay, if not, they can just email it to me and I'll print it off.
Okay.
And has your client been sworn in?
Lupe was about to do that, Judge. He
Yeah,
had him in
Judge,
the
he's ready.
breakout room.
Okay. Well, I do have the paperwork on Mr. Hemphill and I have the paperwork on Dela Cruz. So who is ready?
Well, I would say me, Judge.
All right. Mr. Hemphill, where are you?
Hello, ma'am. How you doing?
Hello. So who is the prosecutor on Hemphill?
That was Hunter.
All right, the court is calling 2020 CR 1091, State of Texas versus Devonta Hemphill. Could I have parties announced for the record for the state?
Robert Maurer for defendant, Your Honor.
All right, I'm sorry, Brenna, okay, it's back. For some reason, the real time went hinky on my computer. All right, we're proceeding by video. Any objections from the state?
No, Judge.
Any objection from the defense?
No, Your Honor.
Mr. Hemphill, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have, and yes, I did.
Court will find that the state is in compliance with discovery. Mr. Hemphill, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is theft, $2,500 to $30,000? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Judge, we've discussed the case. He's gone over any possible defenses with me.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I did.
Mr. Hemphill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am. Very.
Are you a U.S. citizen?
Yes, yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
All right, counsel for the state and the defense, where it says $1,500, in parentheses, it says probated if restitution.
There's no restitution, Judge. I'm gonna ask the court to probate it anyway, but
All right, so that's outside the agreement technically then?
It would be, Judge, but there's no objection
What, no objection to it being probated or?
to Mr. Mauer asking.
Okay. All right, then, according to the plea bargain agreement, Mr. Hemphill, there's a $1,500 fine. Your attorney will be allowed to ask that it be probated. The state is recommending deferred adjudication. And it says restitution to be determined, but my understanding there is no restitution. Is that correct, state?
That is correct, Judge. Information that I obtained after the paperwork was filled out.
So do both parties want me to strike through restitution?
defense requests that, Judge.
State?
Yes, Judge, no objection to removing that.
Well, then the entirety of the agreement is state recommends deferred adjudication. Did you understand that to be the agreement, Mr. Hemphill?
Yes, ma'am.
Defense, is that the agreement?
It is, Judge.
State, is that the agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there many such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is recommending that your deferred adjudication be a term for 4 years. There be a TAP evaluation, 150 hours community service restitution, no contact with Docket, DOGGETT, Freightliner, theft level 2 course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
That's correct, Devontae. Thank you.
State, any evidence to support the defendant's plea?
Did offer states warrant attachments, Judge.
No objections, Your Honor.
Mr. Hemphill, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments in the court will review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, would ask to waive PSI.
Anything you wish to say on behalf of your client?
Judge, I just asked the court to grant Mr. Hemphill deferred. At the time that this incident happened, he was having some financial difficulty with the loss prevention. People talked to him about it. Not only did he return the money that he had made by selling the item, he had the person he sold it to return the item as well. So the company he worked at has been made whole. I think he's a very good candidate for deferred adjudication. And I'd ask the court to probate his fine as well.
All right, Mr. Hemphill, are you currently employed?
Not at the moment. In a couple of weeks, I am. I'm trying to become a CDL driver.
Okay.
I guess, and Judge, if that's the case, I'd ask the court to give him permission to travel for work as he can provide documentation to his probation officer.
Okay. All right, this is what the court is going to do. There's a $1,500 fine that will be probated, 4 years deferred adjudication, 150 hours of community service restitution, or $7.50 per hour to the San Antonio Food Bank. There's to be no contact with Docket Freightliner, theft level 2 course, proof of employment within 30 days. There's to be no employment as a home health care provider or any employment involving minors. Defendant is allowed to travel for work upon proof of employment. Regular Zoom reporting. If your Zoom is not working, then you'll need to report in person. Regular UAs, or you can do the patch, and your attorney will explain to you the difference between both. Random field visits, 1 time per month. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Hemphill, is there anything else you need from the court in order to be successful?
No, ma'am, that'll actually be everything. At least that'll help me for my job.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Hemphill, they're giving you a course. It's a theft course. My theft course is very simple. Don't take what doesn't belong to you. If you have a problem with finances, actually, if you tell people and reach out to people, you'll find that people are willing to help. You understand?
Yes, ma'am.
All right, I'm going to send you to a breakout room. If you will wait patiently in that breakout room, probation will be there shortly, okay?
Yes,
But
ma'am.
do not leave until you speak with probation. So I'm going to send you to breakout room number 3.
Okay, also, will I be able to speak with my attorney too?
Yes, I'll send your attorney to number 3. And then, Robert, I think you have one other person.
I do.
Are you D'Anthony Dixon or no?
Yeah, Judge, that was a restitution hearing. I had him log off. I had requested the hearing. You had granted it a long time ago, but there's some issues about what money the case goes to. But my secretary requested a setting, and I told him to log off, and I just dropped the setting, and I'll approach the court another time. I'm up to my Louisiana rear-ended alligators right now.
Okay, all right.
Thanks,
I'll
Judge.
send, you're welcome. I've sent you to number 3.
All right, thank you.
All right, the court is going to call 2020 CR 6871 State of Texas versus Gregory Dela Cruz. Could I have parties announced for the record for the state,
David Lernon for the state.
for the defense?
Patrick Philipp for the defendant.
And are you Mr. Dela Cruz?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
No.
Any objections from the defense?
No, Your Honor.
Mr. Dela Cruz, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Dela Cruz, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are.
All right, Mr. Dela Cruz, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of employment harmful to minors. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. De La Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,000 fine. State recommends deferred adjudication. You are to provide proof that you attended and successfully completed a court-ordered human trafficking awareness class since the time was arrested for this charge. Did you understand that that was the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
It is, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 2 years, 80 hours community service restitution, and the state recommends the standard conditions of community supervision and not those special conditions assessed to offenders in the sex offender unit. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, the state offers what's been marked as State's Exhibit 1, sent virtually to the court this morning.
No objection, Your Honor.
Mr. De La Cruz, I'm going to show you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just, Your Honor, that we would ask that you grant the deferred adjudication. I know that Mr. Dela Cruz will be an excellent probationer and will discharge all of the terms and conditions of probation. We would ask that Mr. Dela Cruz be allowed to make a donation to the food bank in lieu of performing community service hours, if we may.
Okay. And has he completed the human trafficking awareness class or no?
No, he has not at this time, Your Honor. As a matter of fact, I need to confer with Mr. Lunan about exactly what class may be available to discharge that obligation.
Okay.
But we will do that at the first opportunity, Your Honor.
Mr. Dela Cruz, where do you work?
At Tiffany's Cabaret.
All right, so is he in the same position he was before hiring?
Yes, Your Honor.
Is this a good thing? Is this a bad thing, Mr. Lunan?
Your Honor, we discussed that, myself and Mr. Fillick. I believe it could have some positive implication in that Mr. Dela Cruz is able to be an example to the other managers at these clubs, that there are consequences for their reckless actions in hiring people that could end up being juveniles into their clubs, and that him being present to be a living example of someone who got caught doing it, who ended up paying the price, could be a positive thing for the rest of the employees to know you don't take shortcuts when you're hiring a dancer.
Your Honor, I'd like to add that a lot of remedial action has been taken. The offense in question dates back to 2018. They have since installed a much more sophisticated background check machine. As you may know, the law now has been changed to where you have to be 21 to work in an establishment like this. But they've also implemented other voluntary measures. For instance, they no longer take out-of-state IDs, even though under the law, I think they're allowed to. They will not accept a temporary ID, and just a number of other protocols that they have established so that this never happens again, Your Honor.
All right, and Mr. Dela Cruz, if you're drug tested today, what are the results going to be?
Clean.
All right, this is what the court is going to do. There's a $1,000 fine. That will be probated. 2 years deferred adjudication. 80 hours of community service restitution, or you can pay $7.50 per hour to the San Antonio Food Bank. Human trafficking awareness class. Proof of employment within 15 days. There's to be no employment as a home health care provider or any employment involving minors. Regular Zoom reporting or in-person reporting. Random field visits once per month. Regular UAs, or either you can do the patch and your attorney will speak to you about that and probation will speak to you about that. Rebecca, is there anything else he needs?
No, ma'am.
Mr. Dela Cruz, anything else you need from the court in order to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, I'm going to send you to breakout room number 3. Just wait in there patiently. Probation will be with you shortly.
Okay, thank you.
Thank you,
You're
Your Honor.
welcome.
You judge.
Thank you. Bye-bye.
David, I'll be in touch.
Okay.
And Jorge, we're back with you.
Yes, Judge. I've conferred with my client.
Yes.
And we're ready to proceed, if I may.
Of course. All right, we're back on the record on 2021 CR 4792. All right, and where we left off, I had asked whether or not your client was going to be positive for drugs, and he said he would only be positive for marijuana.
That's correct, Judge. I believe if you ask him again, I think that's still the same answer.
Okay. All right, then, Rebecca, can we get a UA for Mr. Eric Garay?
Let me see if there's an officer able to do one.
All right, we're gonna get a UA for you today, Mr. Garay, and then I'm gonna make a decision on your application. So just wait right there for us in the courtroom. We'll get somebody to come over to take it.
Yes, ma'am.
Judge, this is Stacy Krause. Are you still wanting me to hang around?
No, you can, if you want to stay around, you can. I don't think anybody's gonna recall Miss Garay,
Okay.
but they may.
I don't intend to, Judge.
Meeting, so I just wanted to know if I needed to reschedule it.
Oh, no. Well, the defense is telling me they're not gonna recall her. State, do you anticipate recalling her?
No, we're not.
So then what we could do, if that were to happen, we could let you know, Ms. Cross, but they're telling me they're not gonna recall her.
Perfect. Thank you, Judge.
You're welcome. Thank you so much.
Thanks.
You're welcome. John Young, you're in the courtroom.
Yes, ma'am.
Thank you. Which case did you have? I'm sorry for the wait. Thank you for your patience.
Anthony Salinas, Your Honor, 2020 CR. Gosh, I'm not sure. It's kind of fuzzy.
Oh, I have the cause number. So you're here for a
Request
motion?
that you amend the conditions of his bond to go from partial house arrest to tracking only on the GPS monitor. He works, I would phrase it as light construction. He works for a woman named Amy Sanchez. I've been in contact with her regularly. She needs him to go to various renovation and construction sites. He has to go sometimes outside of town. And sometimes he doesn't candidly get very much notice when he needs to go.
All right. Joe Ray, are you going to have any objections to tracking?
Yes, Judge, we are.
Okay. All right. Let me grab his file. John Young,
There
did you
was
follow
one
up?
time about a year ago, Your Honor, he was, the people at pretrial services received a phone call from his ex saying that he was at her location. Well, she was at the house, I think it was his mother, where the children were at. And he didn't even, neither pretrial services nor he knew that she had moved to that location. He was dropping clothes off and food for the kids. Eventually, he was taken into custody on that. And eventually he was granted release on GPS monitor again on partial. I don't think that, honestly, since nobody knew she had moved to that address, it really wasn't his fault that he was in the wrong place at the wrong time.
Mhm. All right. Just 1 second, because I don't have the motion for that.
And I did want to file a motion. I raised it with you on the 22nd, and you told me to come back today for a hearing on it.
Okay. All right. Let me just have, clerks, could I get the motion on Anthony Salinas? The motion for modification of bond conditions?
Your Honor, I
Please.
had not filed a motion. I raised it with you on the 22nd, and you told me to come back today for a hearing.
All right. State, are you okay with proceeding even though a motion has been filed? Are you okay with going with an oral motion?
That's fine, Judge. We don't object.
All right. So John, is your client here now?
My client is here, Your Honor.
All right, let's bring him up.
I just realized all you had was my tie.
Yeah.
So- Okay, right here. They told me, I didn't realize there was a disc there for a reason.
All right, the court is calling 2020 CR 5977, State of Texas versus Anthony Salinas. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
John Young,
All right, and are you Mr. Salinas?
Anthony Salinas.
We're proceeding by video. Any objection from the state?
No, Your Honor.
Any objections from the defense?
no, Your Honor.
All right, the court will note for the record that Mr. Salinas is actually in the courtroom. And we have a slight issue. Mr. Salinas, any person who's entering the courtroom must wear a mask. I don't know how you made it from downstairs up here. Is there a reason you're not wearing a mask?
No, I forgot it, man. That's correct. No.
Okay, and that person who just gave you a mask, do they have a mask? Yeah, no, the t-shirt's not gonna
I'm
get it.
afraid we've got musical masks, Your Honor.
Okay, I'm not responsible for people exchanging masks. I don't think that's sanitary, but I'm not a medical doctor.
Put it backwards. I don't know.
Mr. Salinas, again, I'm not a medical doctor. I don't think reversing that is
Yeah, I don't think.
helpful either, but
I forgot mine in the, I was working and I was in the room.
all right, we'll have to talk to them downstairs because I believe the new rule is that you can't enter the courtroom without it, okay? All right. So defense, you have an oral motion to modify bond conditions. What are you asking for?
Yes, Your Honor. I would ask that his GPS monitor restriction be changed from partial, which allows him to work, but because of the type of work he has, it's difficult to work with that. And I would ask that it be go to tracking only.
All right, state.
Yes, Judge, we're opposed to the tracking only, given the nature of the offense, which is a repeated violation of a bond or a protective order. Also, he has an extensive criminal history. He's charged as a habitual, both for violent crimes, aggravated assault to deadly weapon, and assault family second. So for the complainant's safety and the nature of the offense, we're opposed to the tracking.
Okay, so then let's try to solve the problem this way, Mr. Young. What is the issue with his work schedule?
I believe that he would be better capable of explaining why he needs to go to tracking, Your Honor.
All right, Mr. Salinas, if you could raise your right hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand and state your name for the record, please.
Anthony Salinas.
All right, Mr. Salinas, what is the issue with GPS?
Just that sometimes I have to start my job early in the morning and I can't leave until 10:30 in the morning. And then I gotta work late. And sometimes it varies on which jobs I get. I resurface countertops and tubs and cabinets and all stuff.
So is it true that sometimes you can't finish a job until later than after the time that they've allotted for you?
Yes. Yeah, I can't, sometimes it needs to, I need to, it's a process, right? You gotta sand it down and so let it dry a little bit, then do it again.
All right, well, this, just 1 second. This is what we're gonna do. Mr. Young, I'm assuming he's being monitored through pretrial services?
Yes, Your Honor.
All right, Norma, is there any way you can have somebody from pretrial services zoom in? The officer for Mr. Anthony Salinas. Mr. Salinas, the court is not inclined to do tracking only. But let's see what we can work out with pretrial services. I'm sure there is some way to get for you to have employment, but yet it be just for employment. So if you'll take a seat, we're going to get in touch with pretrial services and see what we can craft.
Okay.
Thank you,
All
Your
right,
Honor.
you're welcome. Yes, Lorraine Efron?
Yes, Your Honor.
Yes.
I mean, if Joe Ray would just reach out to that detective and see if if that video is in his possession or not and let me know. I think that would be good.
Okay, all right. Joe Ray, do you have an idea when you will know that, or is that case a misdemeanor?
You're talking about the criminal mischief one, right, Lorraine?
Yes, yes, Your Honor. Yes, yes, Joey.
And is that misdemeanor a criminal trial division misdemeanor, or is it felony violence misdemeanor?
It should be a criminal trial one. I mean, it's been closed out for a while.
Well, all these offenses were 18 to 19, 2018 to 19.
Mhm.
All right, so who are you able to get in touch with on that?
I mean,
Judge, can I see you in a breakout room when you get a chance?
Yes. I'll be right there, Rebecca. And Rebecca, it will be breakout room number 2. All right, everyone, just give me one moment. Mr. Garay?
He stepped out, Judge. We're getting him.
All right, thank you. Thank you. Yes. Sure. Okay. Oh, no problem. So is Mr. Garay, your client has gone, Mr. Canales?
Judge, that's news to me. Last I saw, he was going testing. Let me check.
He left, Your Honor.
He left?
Yes.
Okay. Well,
Well,
And Deputy Mejia checked the restroom and he's not there.
okay. All right, then it appears we're gonna issue a warrant for your client.
well, Judge,
It's Monday. What can you say, right?
it's a heck of a Monday. Now I don't even know what the results are.
I think we may have an idea.
Yeah.
Valeria Garay? Maybe he went downstairs to check the weather.
Oh my God. Yeah, it's definitely a Monday.
It is Monday. Well, I'll give him till 3:30, and if he's not back, we'll issue a warrant.
All right, Judge, let me check on him.
Okay.
Your Honor, I'm back from the breakout room on Christopher
Yes.
Lemire. I have an announcement for the court.
Yes.
Meredith and I have partial agreement on
Mhm.
his MTR.
Okay.
And if I say something wrong, Meredith, just jump in. I do have some
No,
witnesses.
that's correct.
I have some witnesses who have logged on.
Yes.
So they'd like to speak on his behalf, some family members. Just a heads up that Mr. Lemire does have some significant mental health issues. He's been in custody for a little while and he's just been restored to competency as of a couple days ago.
Okay, no problem. And Rebecca, I've already sent you to the breakout room with Patrick Phillips Klein and Devonta Hemphill.
Yes, ma'am. Thank you.
And Bobby Gebbia, if you will get your client then out of the breakout room, they're still in breakout room number 4.
Well, we need to do the certificate of appeal, Judge? It is an agreement to reinstate. We're unagreed as to safety.
All right, so what we'll need then is we'll need a consent to appear by video. So
Right.
Norma, if you could get that to Bobby Gebbia.
And I did send Norma a chat.
Okay, then we will do that.
Thank you, Judge.
You're welcome. Oh, Lorraine, Efren, you're back. All
Yeah,
right,
I mean,
so,
honestly, Judge, this is what I think. If Joe Ray will just reach out and let me know, we may not need any further court intervention on this. I'll know, if Joe Ray will talk to the detective and say, yeah, he has it. Yeah, he doesn't. No, he doesn't.
so
then
what's
I'll-
the time frame on this? That's what I'm trying to figure out.
Yeah, but I mean, at that point, I can assess what, if anything, further I might need to do. At this moment, I don't even know.
Yeah, so I'm trying to get a time frame for that because the day is the plea deadline date. So I want to get a time frame for it. So when we bring it back, I'll extend the plea deadline date till when we're bringing it back. But I don't want to bring it back next week and then we're back here because we don't
Yeah,
know the answer to that question.
That I agree with. Plus, the next couple of weeks are so stacked for me.
All right, so that's what we're waiting on. Joe Ray is looking into it.
Judge, I mean,
Everybody put some patience in your pocket.
we can just give them a timeline to respond. And I mean, I'll ask him and see if he has it, one last shot. But if we just give him a timeline, it's still our position that there's reasonable notice on this complainant's offense, we've given the report. She has that information.
All right, so what I'm gonna do then is I'm gonna recall this, Ms. Efron, gonna call it in 2 weeks, so it'll be the week of August 16th. Norma, can we come back on the week of August the 16th on Miss Villalava?
And I'll send the email out today right away. So
Okay.
Yes, ma'am. I'll email you the Zoom link in just a few minutes. Give me 1 second.
Is it possible to do it on the 17th? Or,
Just 1 moment. We shall find out.
well, it's okay. I have a vacation for the 20th.
Okay. No, I'm sure the 17th will be fine.
Okay.
We'll just see what date Norma gives us. If Norma says the 17th is okay, then we'll do it on the 17th.
Okay.
Okay, Judge, I'm sorry. I was on the phone with the pretrial services.
All right, is August 17th okay?
For what, Judge? I'm sorry.
On Edna Villalava?
Sure.
All right, so we'll see you back on August 17th. That's the last plea deadline date the court will give.
Okay. Thank you,
All right.
Judge.
You're welcome. Your client's here and she is excused.
Thank you, Judge.
You're welcome. Okay, Mr. Garay. Come forward. You're gonna go do a UA today. Do you understand?
Sure.
All right, I'm gonna send you a courtroom. Can you go to breakout room number 3?
Yes, Judge.
And Jorge, I'll send you to number 3. Your client is gonna do a UA today, and I should have the results by tomorrow.
And so are we gonna be on hold till tomorrow?
Yes.
Then? Okay,
We're gonna come back tomorrow at 9 a.m.
9 a.m.
Yes,
Thank you, Judge.
you're welcome. Can you make sure he has a reset form to come back here tomorrow at 9 a.m.? Mr. Garay.
Bobby, the paperwork's been sent to your email.
Yes.
I'm hoping that you would set a bond, but I understand that, with all the COVID stuff going on, that you would be certain. Would you just like to paperwork and I go?
Yes, if we just do it, yes, in the courtroom.
Okay.
All right, thank you. You're welcome. All right, is the person here pretrial services for Salinas?
I am Laura Tijerina.
All right, Mr. Salinas, can you come forward, please? Thank you for zooming in. Happy Monday. All right, so this is Mr. Salinas. All right, so Mr. Salinas, we're trying to figure out a way for him to be on GPS plus be employed. He's saying there's some issues with his work schedule that sometimes they have him working later. Like, for example, he may turn in a form to you or a request saying that his work is from 9 to 5. And he gets to the job and then they extend him because there's more than 9 to 5 work. It's extending past that. So how can we craft something so that he can still work and do his hours, but he's on GPS?
So I wasn't aware that he needed extra time in regard to work. He might have told me, Judge, and again, forgive me.
Problem.
I don't recall him telling me that, but he would just need to provide me with the work schedule that he needs to work later. We don't really care for anything to be submitted the same day because it may not be entered in that same day. I don't know, Judge, if you're willing to put him on maybe a curfew until maybe 10, 11 at night for work purposes. I don't know how long Mr. Salinas is requesting or needing for work.
All right, so what is your work schedule, Mr. Salinas?
It starts like from 8:30 to whenever I finish. Sometimes I don't finish.
Well, nobody's having you work at midnight, so let's just stop with that.
Yeah.
Like, so
That's hard.
what is the,
Yeah,
what
that's
is,
hard for us, Judge.
what is the latest you have worked?
8:30. I mean, 10:30. 10:30.
What are you doing at 10:30?
Countertops and tubs and cabinets.
All right, so what is a way, Ms. Tijerina, for us to, like I say, have him do work, but then maybe there's something we can, maybe you all can check after the fact to see if he actually was at work at that time?
We can communicate with his supervisor. There's not really because he doesn't have a set place that he's actually working since he's doing construction and whatnot. So we can, his supervisor can communicate with us to let us know that he was at work until whatever time, but then that's leaving it up to the supervisor to communicate that with us.
Well, here's what I can do. I can give him a curfew. Joe Ray, are you okay with the curfew? And the curfew is for work only?
That's fine, Judge.
All right, so what I'll do is I'll give him a curfew for work. And Mr. Salinas, if work goes outside the curfew that I am giving you, then you need to contact pretrial services and let them know. And I would think by 6 p.m. or 5:30 p.m., you should know that this job is taking longer than what I'm saying it's going to take. So you'll need to communicate with them and say, work is going longer. This is my location. Do you understand? Communication is everything.
Your Honor, can he give them a message on voicemail if nobody answers? Because I'm familiar with sometimes they don't answer there.
Well, I mean, if he leaves a message on voicemail, I'm sure they'll let me know that they received it by voicemail or whatever.
Very
But
good.
he needs to communicate with them that his work is taking longer and he needs to be where he says he's going to be.
Yeah, because it's only voicemail. That's it.
He can do that.
Okay. So I'll give him a curfew. I'm going to give you a curfew of 8 p.m. And if it goes beyond 8 p.m., then you need to call them and let them know. I think an 8 p.m. curfew is fair. Mr. Garcia, what do you think about it?
Here's a question. Let me find out what the question is.
Okay.
From 10:30 to 10:30. I mean, anyone can that. 10:30 from 10:30.
What she's saying is, if you go, she's given it until 8 o'clock. If you go past 8 o'clock, you have to call them and let them know.
Why? You've already got 10:30 to 10:30.
You don't have 10:30 to 10:30.
Yes, I do. What's wrong with that?
No, that's what Miss Tiarina was recommending. I'm not giving you till 10. I'm not giving you a 10:30 curfew. Are you
But I'm
currently
trying
on 10:30 curfew?
10:30 to 10:30. That's my.
I'm gonna bring up his work schedule right now.
Well, we're gonna see what it is. Just give us a second.
1 second, my laptop went offline.
No, no problem.
You know how it goes, it's Monday.
So we just do it.
If pretrial services has already given you 10:30, I'll give you 10:30. But if they have not given you 10:30, then you're not getting 10:30 from the court. You're going to get the 8 p.m. and you'll just need to communicate and call.
Your Honor, my understanding of what you just said is that if he is not going to be back home by 8 o'clock, he needs to call pretrial services.
Yes, and tell them that he's still working at whatever site it is. He needs to give them address and location. And they will check and they will let me know.
Very good, Your Honor.
So is your client saying that his previous work schedule through pretrial services was 10:30?
No, Your Honor, I believe what he was saying was the probation officer's suggestion to you just now was what he picked up on.
Oh, yeah. Okay. Yeah, no, his curfew will be at 8 p.m. We're going to go back on the record. We're back on the record in 2020 CR 5977. State of Texas versus Anthony Solis. This is the court's ruling after a conversation off the record with state and the defense. The defendant will remain on GPS. The defendant will be allowed to work. The defendant will have a curfew of 8 p.m. And that curfew is as it relates to work. Mr. Salinas, if your work schedule goes beyond 8 p.m. and you see that you're not going to make it at home by 8 p.m., you need to inform pretrial services of that. Do you understand?
Yes, ma'am, but
Go ahead, explain to her what your confusion is.
I already had 10 to 10:30 to 10:30. I mean, you're supposed to help me not get hours away. So
You already had 10:30 to 10:30. Why are you here? I'm not extending you beyond 10:30. So why are we here?
We were asking for tracking only, Your Honor. Joe Ray has had an opposition to that.
Because sometimes I gotta go to Austin and New Braunfels.
All right, let me ask you something. Why is it difficult? Why is it so difficult to pick up the phone and call pretrial services? Do you have their number?
Yes, ma'am, but it's because I gotta leave a voicemail and they can't help me.
Okay, so leave a voicemail. I mean, leave a
Do I
voicemail.
leave a voicemail and go?
Yes.
Okay.
I mean, I don't understand. That's the problem with the world. There's a lack of communication.
Your Honor, he thought
Right.
that he had to get their approval before he could go. You're saying he just needs to give them notification that he's going
Yes,
and then be sure he tracks that.
yes. And make sure he's actually where he says he's going to be. If he is not, and they discover that he's at a different location that he told them, we're going to have a problem. So, Mr. Salinas, to be clear, let's assume you're working at 300 De La Rosa and you're supposed to be home by 8 p.m. And your employer at De La Rosa says, we're not done yet. You're going to be here till 10. So what you do is you pick up the phone, you call pretrial services. You tell them your name, your case number. I know I'm on GPS. I'm at 300 De La Rosa. I've just been informed that this job is not ending till 9:30 or 10. And then what will end up happening is pretrial services will be able to check that GPS. And if you were not at that location of 300 De La Rosa where you said you were going to be, there's going to be a problem. If you are working at 300 De La Rosa, then there will not be a problem. Do you understand?
Yes, ma'am.
All right, is there anything else from either side?
No, Your Honor.
Miss Tiarina, does he need any information from you?
No, so he's still allowed his work schedule. He just has to communicate in the event he is working later than expected.
Yes.
And clear, Judge, Mr. Salinas has been communicating with me that he is running home late due to vehicle issues. So he has been in communication with me these past few nights. I've been getting the voicemails. I put him in his file. So he has been in communication with me. I just want to, make that clear that he.
Okay. All right. So there you are, Mr. Salinas.
Thank you.
Thank you, Your Honor.
You're welcome. Just stay in contact.
Okay.
All right. And Mr. Salinas, we'll see you on August 6th for jury trial. All right. Thank you.
Thank you, Judge.
Thank you for coming in. Hi.
Hello, Your Honor.
Hello. Did you speak with Joe Ray about the bond or no?
I have not, Your Honor, but just to let the court know, you are the presiding court, so Judge Moore is out for the day. So
This is from the 186.
Correct, it's from the 186. Also, I think you need to know, as an officer of the court, I need to tell you, the MTR, the motion to revoke that you have in front of you, it says 3 assault cases. They're actually aggravated assault cases. So it makes
Okay. All right, thank you very much. I tell you what, let me call Judge Moore and see if there's something specific he wanted this bond set at or not, okay?
Yes, Your Honor.
And who is the family violence prosecutors in his court?
It's Ashley Jones and Chris Ramos. I believe, though, from what I remember seeing in the system, it's just a regular assault. It was, I guess, charged as aggravated and then reduced.
Okay, so it would be criminal trial division?
It would be criminal trial.
All right, so who are the criminal trial division prosecutors?
Andrew Fields, I believe it's Austin Stout, and I'm drawing a blank on the third one.
All right, could somebody see if Andrew Fields can zoom in here? Just give me one moment.
Hi, Mom.
Christopher? Can you hear us?
Yes, I can hear you.
Oh, you sound sick. Right. Yeah. I've got to take this apart to get the video.
Where's Chintu? It was good before pointing at both of you.
Christopher and family, let's hold off on the chatter until the judge comes back, okay? We are live on YouTube. When the judge calls your case, then you'll all be called and you'll have your opportunity to have your case heard. But right now is not the time to talk, okay?
All right, Daniel, the prosecutor from that court is going to zoom in very quickly.
Okay,
All right, thank you. Thanks for your patience.
okay, thank you.
All right, is anyone ready?
Judge, I think we're ready on Mr. Christopher Lemire. It's an MTR. We signed our documents. It is a partial agreed recommendation. And we have a couple of witnesses who've logged on.
All right, we will take that matter up. Hey, who's the prosecutor on this?
I was working with Meredith, Judge.
Okay. All right, the court is calling 2018 CR 0858, State of Texas versus Christopher Scott Lamar. Can I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
Robert Gebbia for the defendant.
And are you Christopher Lamar?
Yes, Your Honor.
All right, how do you spell your how do you say your last name?
Lemire. It's
Lemire.
okay. It's okay.
All right. We're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Lemire, did you review a document entitled Defendant's Consent to Appear by Video with your attorney, and did you understand it?
Yes, Your Honor.
All right, the court will find the defendant has knowingly and voluntarily consented to appear by video. Mr. Lemire, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt. Did you review that document with your attorney, and did you understand it?
No, I haven't seen this. No, he didn't show me this paper.
All right, do you want to have a chance to discuss that with your client, Mr. Gebbia?
Yes, please, Your Honor.
All right, Mr. Lemire, I'm going to send you to a breakout room with your attorney. Let me see. I'll send you to breakout room number 1. It should pop up on your screen, Mr. Lemire, for you to go to number 1. Do you see at the bottom where it says breakout room? Do you see where it says participants? Chat? All right, Norma, can you get someone to help
I
Mr.
see
Lemire?
participants, chat, share screen. Oh, breakout room.
Yes, if you go there, please. All right, Chris Ramos?
Yes, ma'am.
All right, hello.
Hello.
To the 187. Let me find it. All right, Chris, Daniel's asking for a bond,
Hey, Chris.
and the cause number is 2018 CR 3319. It's Timothy James Lounsdale. So I'll send you all to a breakout room to discuss a bond amount.
Yes, ma'am. Thank
If
you.
you can't agree on it, let me know and I will make the call. I'll send you all to breakout room number 2.
Thank you, Your Honor.
Yes, ma'am. Thank you.
You're welcome. Brenda, I took allergy medicine, so I have to drink a lot of water. I'm dehydrated a little bit right now.
We don't get very, a lot of attorneys that know how to work.
I know a little bit.
Hi, so do you guys have an agreement?
Yes, ma'am. On the MTR,
Yes.
which is a misdemeanor assault, state can agree to $5,000.
Okay.
No contact with complainant, as I believe it's already a part of the conditions of probation.
All right, just one moment. So you say on this one, $5,000?
Yes, ma'am, on the MTR only though.
All right, and you say no contact, and who is the no contact with?
It's gonna be on the complainant. If you'll forgive me and give me one moment just to
Okay.
obtain her name. Judge, if you can include no contact with Sherry Altman,
Is that SHERRY?
SHERI, Altman, ALTMAN.
All right, anything else?
No, ma'am.
All right, thank you for zooming in so promptly.
Thank you, ma'am.
All right, have a
Thank you,
good
Your
one.
Honor. Thank
You're
you.
welcome.
Thank you.
Thank you all.
And Daniel, you can pick this up from the back.
I will, Your Honor. Thank you.
Okay.
Thank you.
All right, Bobby Gibbia, you're back. You ready to proceed?
No, Your Honor, I'm going to go over the MTR with him, just a little bit closer.
Sure.
I know that Laura Zachariah has gone over it with him already because it says so in my documents, but his file is so big, I can't find the MTR right now. So Meredith is going to email me one. I'm going to go over it with him again just so he understands everything, okay? And I'll be right back.
Okay, sure. Oh, no problem. And who are the prosecutors, or who would be the prosecutors on DeAnthony Dixon? It was on the docket today for a return of property.
Judge, they canceled that one. Robert said he'll come back at a later time.
No, I know he canceled it, but I'm trying to figure out what is actually going to be happening on this case, because I don't have in the system that there's any other upcoming date. Because what I have is I have 2 motions to revoke. Is there still going to be a motion to revoke? Because I have that the new number 1 was dismissed. Does anyone know?
Sorry, Jen, which case is it?
It's DeAnthony Dixon. It's 2018 CR 11623A. And then I have 2018 CR 12005. I mean, does he has a motion to revoke or no? Does he have nothing?
Judge, it doesn't show in the system. On CJS.
Pulling it up, Judge.
Okay, because I'm just wondering.
Judge, I don't see any MTRs on file on probation side.
Okay. All righty.
I don't see anything either, Judge, in judicial dialogue.
Okay, then the last case that we have, I think, is Lemire.
Judge, what happened on Ruben Hernandez on the MTR docket?
Ruben Hernandez. Oh, that's coming back on August 23rd.
Thank you.
You're welcome.
Judge,
Yes.
on Dixon, just a note in JD, it indicates that there was a motion filed for return of property in one cause. Well, there was a motion filed in both causes on the same date, January the 4th. A ruling was made on the 15th in one cause. That is CR 11623A, the organized criminal activity. But it does not look like there was a ruling made in the other cause. And those were filed at the same time. I don't know if the court's file reflects the same.
Let me see.
I haven't compared those filings to see if it's the same filing or not. But
Oh, no, actually, it was reset on January 15th at the defense request. So that one I haven't ruled on.
oh, okay.
Yeah, and then now this one for the case that's closed, it's been withdrawn as well.
Okay.
So I don't know if it's going to be reheard, but I know it's just maybe not going to be heard today.
I see. I know that the civil case is still pending as to Mr. Dixon.
Okay.
For same properties.
Brent, I sent you a chat. Norma, while they're doing that, do you want to go in a breakout room and go over the docket?
Yes, ma'am.
All right, I'll send you the number too. Everyone, I will be right back.
Mom, you might need to get the bottle of Adderall to show the judge that it was not using methamphetamines.
Christopher, again, now is not the time, okay? We're gonna have the opportunity to talk, okay?
Are we gonna have a plea of truth though?
Yes, plea of
Okay.
truth, condition number 2, failing to submit in January 2020.
Oh, okay, that's not the one I was gonna read.
Yeah, he'll
Can we
plead
go into a breakout room real quick? I don't want to start this and then have to stop it again. Let me, can you go back to, let me see, were you in a different one with him? Which one were you in? Yeah, go back to 1.
Bobby? He's in a breakout room with the attorney. Everyone, just give me a moment, please. Bobby, are you ready?
Yes, I am, Judge.
Okay. All right, we're back on the record and cause number 2018 CR 0858, State of Texas versus Christopher Lemire. Mr. Lemire, where we stopped off, I was showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney and did you understand it?
Yes, Your Honor, I have.
Are you saying Christopher Scott Lemire, who was placed on deferred adjudication and cause number 2018 CR 0858 for the offense of burglary of habitation with intent to commit assault on May 13, 2019 for a period of 6 years? Is that you?
I didn't understand the question. Is the 6 years the amount of probation they gave me?
Yes.
I believe it's 10 years.
No, you're on deferred adjudication for a period of 6 years.
Okay.
Are you the same Christopher Scott Lemire who was placed on probation and cause number 2018 CR 0858? Is that you?
Yes, Your Honor.
All right. And that probation or deferred adjudication, that's what it's called. Was that deferred adjudication for the offense of burglary of a habitation with intent to commit assault? Is that you?
Yes, Your Honor.
All right. And was that, were you placed on deferred adjudication May 13, 2019?
That sounds about right.
All right. And you were placed on deferred for 6 years. Do you understand?
Yes, Your Honor.
All right. And is that you?
Yes, Your Honor.
All right, state.
On or about the 10th day of January 2020 in Bexar County, Texas, the defendant, Christopher Scott Lemire, did then and there fail to submit to drug testing as directed by the supervision officer and/or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that, true or not true?
I was running late, so I guess true.
Okay.
And then on or about the 21st day of October 2020 in Bexar County, Texas, the defendant, Christopher Scott Lemire, did then and there illegally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that, true or not true?
Not true.
Okay.
Your Honor, I believe there's one more violation, the condition number 1, that the state will be waiving.
All right. So state, even though the defendant has pled not true to violation of condition number 2, the offense that's alleged to have been committed on October 21st, 2020, are you prepared to proceed or would you?
Your Honor, the state believes it's probably in everyone's best interest to just proceed with the plea of truly absent one condition.
Mr. Lemire, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
All right. Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
All right. The court will find violation of condition number 2 true. Is there an agreement?
Your Honor, we have a partial agreement on this case. The agreement is that you deny the motion and continue him on his deferred adjudication. Where we do not agree is probation in the state feels like he needs SafeP, he needs inpatient treatment. He also, we would like the court to alter and amend his conditions to include a no harmful or injurious contact order with his mother, Celeste Lemire, as well as a no contact order with his home address in Spring Branch, which I am pulling up right now. Hold on. Based on some incidents that keep happening at his family home. which I'm sure Ms. Lemire can testify to if that's what she's here for. Let's see here. It's 184 Algarita Lane, Algerita, Algarita Lane, Spring Branch, Texas, 78070. Probation's also asking that he be supervised with the MIC caseload. I think that's about it, Your Honor.
All right, defense?
Your Honor, we're asking the court to deny the motion to revoke and enter an adjudication of guilt. We are in agreement on that. Where we are not in agreement is the safe P recommendation by probation. We are asking that he be sent to a facility, a live-in facility, and we have witnesses here who can testify, his family, that they have done some research and some legwork on some facilities that they would like for him to go to. This one facility that they've made me aware of, and they have sent over to me some information, is AACOG eligibility, as long as some other eligibility that they may have. I have his mother and his grandmother here to testify. I think whenever the court is ready, I could call them one at a time. And if we could just get one singular person who's testifying on, and then we could switch the camera to the other person, please.
All right, before they come on, what facility are you asking that he be placed at? And has he been approved to be placed at this facility?
Yes. Yes, he has been approved. And I do have some information from his family that was sent to me that he is approved to go.
All right, and has the state seen this?
I know that they have. I don't know if this particular prosecutor has. Laura Zachariah was working with Sally Unkefer on this case down in the magistrate's court.
Okay, well, if you can email that to Miss McIntyre.
Yeah,
And
that'd be helpful. I see notes about the correspondence, but I'm just not familiar with how that program is run.
Yeah,
no problem. I'll send it to you right now.
If you can email Miss McIntyre, include me in the email.
All right. That is going out right now.
Mm-hmm.
Give me a second to close my door. I got a lot of noise in the hall.
Sure.
That information should be in y'all's inbox by now.
All right, I'm still waiting for it to appear in mine.
I got stephanie.boyd@bear.org.
Yeah, let's not be announcing my email address on Zoom, please.
I'm sorry, Judge.
On YouTube. Now I'm just going to get a bunch of emails. Thank you, Bobby Gebbia. All right, Meredith, let me know when you receive it because I have not received it.
I could share screen too. If that, well, I won't do that.
I still don't have it.
That's really weird. Let's see if I could try something different here.
There was a flickering of lights, Brenda. You know that happened in Poltergeist. Okay, I've just received it.
All right, then there are 7 attachments. Maybe that's why it took so long. Lots of doctors, family letters, information on AACOG, an attachment from Dr. Scott, and a number of other things. You'll see from Dr. Scott that on his first interview, he was not competent. He was only restored to competency a few days ago.
All right, everyone, let me know when you're ready to proceed. All right, we were off the record. The court has reviewed the documentation without objection that was sent to the court and to the state. And Mr. Gebbia, I read that. It doesn't seem like that would be an appropriate placement for him. And it doesn't appear that it's an inpatient placement. And based upon the fact that the state is requesting no harmful or injurious contact, and then no contact, to me, there's more going on than just intellectual issues.
Right, Your Honor, and that's the main issue the state has. It's not that we want him to be revoked or even sent to prison or anything like that. The main issue is that we want him to be successful in an inpatient environment because we don't believe outpatient is appropriate. And unless the family has changed their tune, I don't think that their home is no longer an appropriate place for him to be. So hence why we recommended Safe P. But if there's another option that can be presented that is inpatient, that he qualifies for, I mean, the state would entertain it.
So do
Well,
we have,
Yeah, we have two witnesses here. These programs are the programs that we've been discussing. My understanding is they're the programs that the family has been asking for. They may have some new programs. We could go ahead and swear them in and maybe they can clear some information up for us.
all right, the main thing that I'm going to want to know is whether or not, Mr. Lemire is going to be staying with them. Like, does he have a place to stay? Those are the main issues that I would like to have addressed. All right, so who would you like to call, Mr. Gebbia?
Start with his mother, Celeste.
All right, could you please unmute for me, please? Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Oh, I'm sorry, I can't hear you. Could you speak up?
Yes, I do.
All right, could you state your name for the record, please?
My name is Celeste Lemire.
And spell the first name, please.
Celeste.
All right, defense.
Celeste, would you tell the judge the nature of your son's intellectual disabilities?
Yes, he has been diagnosed with Asperger's syndrome, which is on the autism spectrum. And then he's had provisional schizophrenia, which is usually dependent on if he's been prescribed a stimulant. So it's never been a methamphetamine. It's been an amphetamine that was prescribed by one particular doctor.
I understand. Now, the judge's main concern, let's just get to that right now. If Christopher is reinstated on probation, what type of opportunities does your family's healthcare or your healthcare providers or your health insurance, or what other facilities have you researched that are potentially made available for him?
So we have looked into the group home option where, we're wanting also a long-term success. In the past, when he was first taken in for this issue, they put him in inpatient for 6 months in SASH and then discharged him saying he was able to withstand trial. And then we had the same issue. He needed medication management, and this group home situation through the ACOG organization, and the name of the actual group home provider that we found is ResCare. They do medication management. And they would take them to their appointments and help them stay organized. They have a lot of teaching opportunities for intellectually disabled people there. It's a very supportive environment, and we have done a lot of research, so we feel that it would be a great success for him. When he went inpatient, if he's in any kind of incarceration plus being in a facility inpatient for over 12 months, then he loses his Social Security and along with that is Medicaid. So then he loses his insurance and he loses his income. So he then gets homeless because, he doesn't have any income coming in. And that income is necessary also for this group home eligibility. So
Now-
we're concerned of the cycle repeating with him going inpatient again, and then he'll be out on the street. Whereas if he were able to keep his Social Security by not being incarcerated or inpatient for over 12 months, then he has the eligibility criteria.
Now, how long has he been incarcerated pending this MTR and his competency issues up to now, since my office has been involved? Seems like it's been about 4 or 5 months. Is that right?
I believe it was January, February. It was before the freeze.
So even longer than that. So he's been in for a while now.
Right, yeah.
Now, the state prosecuting attorney here has some significant concerns about your son returning to your home. So much so that he is asking this court, she is asking this court for a no contact order with your physical address. Is that something that you're asking for as well?
I would like that if he could be in a group home, that he stay in the group home, and then I will support that effort. I feel like he's going to be successful where he has medication management.
Mhm. Tell us a little bit more about this res care facility. Is this paid for by family health insurance, his health insurance, Medicare, Medicaid?
It's paid for by Medicaid. The government splits it between federal, from my understanding, between federal and state, but it is through mainly Medicaid. But
Now, when you say it's a managed facility, does that mean inpatient, which is what the state prosecutor is asking for, which means that he's going to be locked down in that facility, or does he have to live somewhere else and then be transported back and forth?
he would live in that facility. They don't consider it a lockdown, such as SASH, but he would live in that facility. So if it were court ordered, that's what the family is hoping for. That way, and he wants it. He really wants to be there.
Okay. All right, so then it wouldn't go so far as to be an inpatient facility, but it would serve at least some of those purposes because it would be court ordered, mandated by his probation, and he wouldn't be allowed to return to your house, right?
Yes, sir. And they have their own doctors, their own psychiatrists, their own nurses, and they have counselors. And I was told that they actually will up the level of counseling, especially at first if they feel that they need maybe daily counseling. So
All right,
they have a
and-
lot there.
These accusations or these alleged violations of substance abuse, which is why the treatment recommendation is what it is. Tell us about any substance abuse disorders that Christopher may or may not have.
I'm sorry, I wasn't aware of that. So I was a little surprised to hear the methamphetamine. I don't know.
So in your experience, the only drugs that he's been ingesting are drugs that had been previously prescribed to him.
Yes, sir, by a one family doctor that has the wrong diagnosis. He has an old diagnosis in early childhood. He was diagnosed ADHD, and then that was by just a regular pediatrician. When we finally got around a few years later to a psychiatrist, then he correctly diagnosed him with the Asperger's, autism, and bipolar disorders. So then he was on different medications for that. But this family doctor keeps giving him the wrong thing, which has a severe adverse reaction for him. And that's where all the problems have stemmed from. So
I'm going to go ahead and pass the witness to the state. So the state prosecutor is going to ask you some questions, okay?
Right,
Yes, sir.
I just have a few questions. This res care that you're talking about, you said it's not lockdown, right?
Right. So that's why we're asking for court ordered.
But my question is will he be able to, would he be able to check himself out or come and go as he pleases?
He could check himself out. If it's court ordered, then I would assume he would be going against his probation orders.
Well, I guess what I'm asking for is just, since y'all are the one that found this facility, how it's set up to ensure that he doesn't get out and cause your family a problem again. Correct? I mean, aren't we here because of all the issues that has been going on at the home?
All stemming from medication, lack of medication management. He's easy to be around and he functions very well as long as he's not on stimulants.
Which is the Adderall?
It's the Adderall, which is called amphetamines.
Okay. And just to clarify for the court, because I don't want there to be any confusion, does he have a place to stay at your house? Is he allowed at your home?
No, ma'am.
Okay. No further questions, Judge.
All right. Any other questions from the defense?
Just one blanket question, just to make sure that Ms. Lemire has the opportunity to say everything that she wants to say. Is there anything else that you'd like to notify Judge Boyd about before the judge renders her decision?
Yes, ma'am. I actually dropped off a letter to the court, a family letter, and it had everything outlined for you. I was hoping that you would be able to read it, because we spent a lot of time, his grandmother and I, making sure that every point was covered in that.
No, I do have the letter and I read everything that's given.
Okay, at 3 pages, we listed mandates and bolded and underlined them so that it would stand out for just our wishes for you to at least consider. One being on the, toward the end, I think, was the financial forgiveness. He's indigent, so, I mean, that's a problem for him. He's never worked. He worked in all of his life, maybe 2 times for less than 2 weeks. He wasn't able to withstand it, hold a job down. And again, so if he goes inpatient and we lose his Social Security, then his future is a problem because inpatient eventually is going to let them out. So we're hoping to keep the continuance of his Social Security and Medicaid so that he can have a plan. And we would like him to be in the group home as well, because, I'm the only one living to support him. And if something were to happen to me, then, he's a mentally disabled person on the street. So we'd like to get that going and get him used to it. And it's not just this one res care facility. ACOG connects us to many different providers so that he can, if one doesn't work out as well for him, that they will help transition him to another one that works better.
Okay. Anything else, Mr. Gebbia?
No, thank you, Ms. Lamar.
Right,
I
any
just,
other-
one more maybe possible, I don't know if you could stipulate that he is to be prescribed medicines only by a psychiatrist and not one that's not focused on psych.
Okay.
That's been our issue.
All right, anything else? Mr. Gebbia, any other witnesses?
No, I don't. Arlene, do you have anything that you'd like to add, or did Celeste cover it all for you?
Is he talking to me? Are you talking to me, sir, or to the judge?
I was talking to Arlene, grandmother. Would she like to testify as well?
Yes.
Okay, hang on one second. Your Honor, we'll call Miss Arlene. I don't know what her last name is.
Darlene with a D.
Oh, Darlene. Okay, sorry there, dear. Darlene.
That's all right.
And what's your last name?
Trounson, Trounson.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. Defense?
Ms. Trounson, do you have anything that you'd like to add to what Ms. Celeste has already provided to the court?
Yes, sir. I'm holding up, this was an attachment to that family letter, and it was by Dr. Scott, who was a court-appointed psychiatrist. A jail contracted psychiatrist that evaluated Christopher when he was in the other time on this, before he wasn't able to
yes,
probation. It's and in that letter, that report, Dr. Scott said that he believed that he said he may be appropriate for the outpatient program if he has supervised housing available to him. It was talking then about competency, but it would apply for any kind of mental health program. He believed that if he was in supervised housing, and he's a psychiatrist, if he was in supervised housing, that he would be able to be an outpatient. He'd be able to keep his probation. The key is always medication management. And the family is just not equipped. We're not professionally equipped to be able, but if it was mandated by the court for him to be in this group home, stay on the medication management, I believe that he would make it, he would do well, because he's been able to keep probation before with our help, but the medication management has just gone awry because we've got this doctor who's working against us that he can get on a bus and go he Christopher said that, he's
he's not going to take the prescribed amphetamines anymore because there was a different diagnosis by a psychiatrist. He needs medication that is prescribed by a psychiatrist and then somebody to manage his schedule for him. And we believe that.
Hold on a second. Hold on. I'm going to pass the witness. Meredith, do you have any more questions?
No, Your Honor should have all this information already. I
Yeah,
don't have any
we have
questions
all of
on the
that.
diagnosis.
And I do have all of the information. I just want to let everyone know, all of the information that I receive, I always read it. Sometimes people wish I wouldn't read everything that I receive, but I read everything. I make sure that whatever I have, the state has and the defense attorney has. So I've read everything about your son and your grandson.
Thank you.
Thank you.
All right, is there anything else from either side?
No, Your Honor.
No, Judge.
All right, so this is the question for the court, and this is what we have to do. Obviously, there are some issues here, and there's some mental health issues, and it's more than just the fact that he's on the autistic spectrum. So then the question becomes, he can't stay with his mom or his grandmother, which I think, based upon history, he shouldn't be allowed to stay there. So the next question becomes, is SafeP the appropriate place? Personally, I don't believe that SafeP is the place to treat mental health, but I do think SafeP is the appropriate place to treat someone if they have mental health plus drug issues. Based upon the testimony from the mother and grandmother, it doesn't appear that there is a drug issue. It appears that there's mental health issues, there is medication issues, there is a housing issue. So what do we do with that? I'm going to deny the motion, but we need to get together and craft where he's going to be living, who's picking him up from the Bexar County Jail. I heard that this program, the Reyes program, but are they going to pick him up from the jail and state to make sure that things are appropriate and he's appropriate in society? I'm going to want him to be on GPS, but then I need to know is where he's going, will they allow him to be there on GPS? So we'll know if he leaves. These are the questions that I need answered for me. And so the other question on top of that is, will anybody have those answers for me today? As far as if he's placed in this facility or at this facility, will they allow him to have GPS? Does anybody know that? It seems that Ms. Lemire and the grandmother know. Yes.
Yes, ma'am. When we spoke with Bara of Res Care, she asked us herself if he would possibly be on GPS, and we didn't even know that that was something they did. And she said that they had other clients there that, so it is something that they do.
And they are used to, and she told us that they're used to helping people keep their probation, that this is nothing new for them, so.
All right, so now that question's been solved, the next question I have is, will they transport him from the Bexar County Jail?
Yes, she said that they will actually pick him up and take him to the group home.
Well, Bobby, it appears that the mother and the grandmother should have been sworn in as expert witnesses.
Yeah, they're on top of it. They've been on top of it since day one, Judge.
All right, so then the next question, Mr. Lemire, can you unmute yourself?
Yes, Your Honor.
All right, here's the thing. Your defense attorney, the state, probation, your mom, your grandmother, they're trying to help you and make sure that, one, you stay clean and sober, two, that you stay on your medications. But none of this is going to work if you don't want to do it. Now, I have plenty of people who want to be on probation, want to work, and they want to do it. And what I've discovered is people who have mental health issues, they may have medication, they're on it, they start feeling well, and then they say, I'm feeling well, I don't know why I have to take this medication, I'm having side effects, I don't want to take it anymore, I'm doing fine. And then what ends up happening is we end up with another motion to revoke, and we're right back here. So my question for you, and defense, do you mind me asking Mr. Lemire a question?
Absolutely not, Judge.
All right, Mr. Lemire, My question for you is, do you want to be continued on probation? That's the number one question.
Absolutely, Judge Boyd.
All right, so how are we going to be doing things different so that we won't end up back here with your mom, your grandmother doing all of this
Well,
research for you?
Well, for one, my mom didn't tell you that she tried to run me over with the Honda Civic that was my grandmother's vehicle. So she's got mental issues too because she's been on psych meds before, as well as my
Okay,
dad. So that's where.
Christopher, that's
Let me get back to the
too
question.
much.
What am I going to do differently?
See, here
I'm
you
gonna
go.
s-
This is how you find out information, people. Okay, go ahead, Mr. Lemire.
I've had issues living with my mom before, so I should have known that wasn't going to work. So I agreed to go into the group home instead of living at her house. And I agree that I should not be taking that stimulant medicine because it has an adverse reaction. So I won't be taking that anymore. And also I made agreement that I would be going to a particular church each Sunday, which I'll be starting right away, just to meet some friends and also and because of my beliefs. And what was the other question?
Wait, what church? Because you trailed off. You said because of your belief.
It's a first Assembly of God church.
All right. So state, they're saying they have this facility. They will pick him up. He'll be on GPS. He'll be staying there. Is there any objection to that, or you still think the most appropriate place is safety?
No, I don't have an objection after hearing testimony. And I believe the mom and grandmother, I think they've done a lot for him. It's possible that it was a misunderstanding with probation when it came to methamphetamine versus Adderall. And so I'm in agreement. I think that's fine as long as he's monitored. The main concern was his ability to just freely come and go when he needs significant structure.
All right, I'll alter the main conditions. There is to be, let me see here. I guess we're still doing the no harmful or injurious contact with Celeste Lemire. But Mr. Lemire, do you want to have contact with Celeste Lemire? You're saying that she tried to run you over with the Civic.
Well, I've forgiven her before because it's not the first time she's tried.
All right, so do you want to have any contact with her or no contact with her?
She's got to be able to bring me my stuff since I won't be going over there. She'll be bringing my computer equipment and other stuff that belongs to me to the group home. So I need to be able to have some contact with her. My grandmother can't drive.
All right, so there's no harmful or injurious contact with Celeste Lemire. There should be no contact with, to the clerks, could I have another docket sheet, please? No contact with 184 Allegrida Lane in Spring Branch, Texas. 78070. Mixed supervision. GPS. And we're going to start him off with full GPS at the location, Mr. Gebbia. And if they come to me and says that he should get more freedom, then I'll consider that. So that'll be full GPS. And this is at Reyes. Is that correct?
Correct, Your Honor.
Do we have an address?
215 Shadywood.
Is that correct, mom and grandmother?
Yeah, yes, ma'am. 215 Shadywood, San Antonio, 78216.
All right, full GPS. Defendant is to reside at Reyes House at 215 Shady Wood. Defendant is to be transported from the jail by a representative of the Reyes House.
It is called Res Care.
Res, R-E-Y-S, or is it R-E-Y-E-S?
R-E-S and then C-A-R-E, care,
Ah,
like residential care.
all right, thank you.
The lady needs, I don't know if I can speak, but the lady needs, the Bara, the group home lady needs an inside contact for the transport, somebody to tell her when he's released.
What will happen is when I send you all to the breakout room, the attorney, Mr. Gibbia, will be there, so he'll have the information.
Thank you.
All right. Brennan, I'm sorry, Rebecca, is there anything else that he needs?
I just had a question with this res care. Is this something he's already approved for? Or is this something that paperwork needs to be done?
They're holding a room open for him at Res Care. Yes, he has been made eligible through the Alamo Area Authority.
All right, awesome.
And they had him sign consent papers in jail. They brought it to him.
Yeah.
Okay. All right, then, and Mr. Lemire, when you get there, you're going to need to do a release for probation so that probation can see how you're doing there. Do you understand?
Yes, Your Honor.
All right, Mr. Lemire, is there anything else you need from the court in order to be successful?
About how long do I need to be on the GPS?
Until further notice. I'll receive reports, and if I receive reports that are good reports, I'll consider maybe removing you from GPS, but for now, you're going to be on GPS till further notice.
Yes, ma'am.
And if we can put him on indigent status with regards to the GPS. All right, I'm sorry, Miss Lemire, you both had your hands raised for something?
Yes, ma'am. What about probation fines? All of his income will be going directly to the group home provider. So he's,
The main concern the court has is for him taking care of his mental health issues. So probation will make sure that I understand that. All right, is there anything else from anyone?
No, thank you, Judge. I know that this was a long hearing and I appreciate your patience and the time you took to read everything and hear everybody out. I appreciate that a lot.
Well, thank you very much. All right, so what I'm going to do is, Rebecca, I'll send you to a breakout room with Mr. Gebbia and Mr. Lemire, and mom and grandmother, you can stay on, and the defense attorney will tell you everything afterwards, but I can't have you in the breakout room with probation and Mr. Lemire and his attorney, okay?
okay. Thank you
Yes,
so much.
Thank you, ma'am.
You're welcome. I'll send you all to breakout room number 3. And so Bobby, I'll see you to number 3.
Got it. Thank you very much, Judge.
You're welcome. And everyone, I am going to stop the live stream. Hopefully the thunderstorm rain, at least that stopped. So tomorrow will be another day and everybody's flowers and grass should be doing okay. So I'm going to stop live stream and see everyone back tomorrow.